Hello and welcome to WITA, and thank you for joining us for this first event of 2026 in our series looking at important WTO matters in advance of MC14. It's our hope that this seminar series will be especially helpful to individuals who may be supporting their ministries in advance of MC14 and others interested in the structure and functioning of the World Trade Organizations. The next two events in our series will look at expectations for MC14 and WTO reform and feature the WTO ambassadors from several countries, including the United States, the EU, Brazil, Cameroon, New Zealand, Barbados, Norway, South Korea, and hopefully one or two more whose invitations are still pending. The first of those events on MC14 and reform is next Wednesday, February 4th, and the second reform event is February 13th. We'll be announcing additional events in this series in the coming days. The entire series will be free to attend thanks to the support of our WITA International sponsors, the National Pork Producers Council, Trade Data Monitor, Coupang, Visa, U.S. Council for International Business, the National Foreign Trade Council, and the Information Technology Industry Council. Information on these events and our big congressional trade event and our 2026 International Trade Conference can be found on our website, www.wita.org. Thank you. As you know, if you've joined us for one of our webinars in the past, we like to call out the names of some of those you're in community with on Zoom, even if you can't see them on screen. So welcome today to Bevan McDonald, who's the ambassador and permanent representative of the Mission of Guyana to the WTO. Chayam Pandachi at the Ministry of Public Health in Thailand. Cindy Allen, who's the Deputy Secretary of State for International Trade in the state of Nebraska, and Henry Gao at Singapore Management University. Welcome, Bevan, Chayam, Cindy, and Henry, and welcome to all of you. If you're watching this on Zoom, you can ask questions of our panel using the Q&A tab, which should be found somewhere on your screen. If you're on a desktop at the bottom, if you're on a phone, it'll be at the top. And you should have also received a copy of today's event program by email. That email contains a link to see biographies of our panelists. One final note as I ask our panelists to please turn on their cameras. As a reminder, what we say today on this webinar is current based on what we know today, January 29th at 9 a.m. U.S. Eastern Time. But things are changing quickly, so if you're not watching this live, things might have changed.
To kick off our WTO series this year, we thought we'd start with the basic fundamentals of the World Trade Organization, how the WTO was established, its basic functioning and organizational structure, and then we'll discuss topical matters. We're especially pleased to be joined today by our guests from the WTO Secretariat, who are speaking in their personal capacity, and their views do not necessarily reflect those of the WTO members. Eugenia Lizano, Chief of Section Trade Policy Review Americas, Roy Santana, Secretary of the Council for Trade in Goods. Santiago Wills is Director, General Counsel, and Trade Negotiations Committee Division. Thank you for joining us today from Geneva. And coming to us today from Washington, D.C., we are pleased to welcome Padideh Alaoui, Professor of Law at American University Washington College of Law, who will discuss dispute settlement, which is one of the more controversial matters in the WTO system, and our moderator, Angela Ellard, a non-resident senior advisor for the Center for Strategic and International Studies, a former Deputy Director General of the World Trade Organization. Angela is a longtime friend of many of us in the audience and our partner in creating the curriculum for this seminar series. Welcome, Eugenia, Roy, Santiago, Paddy, and Angela.
Well, thank you very much, Ken, and thank you to WITA for hosting this series on the WTO. And of course, thanks to the panelists, many of whom were my former colleagues, and it's so great to see everyone. I want to thank the audience for their interest and hope that they will tune in to the subsequent sessions starting next week. So for today's discussion on fundamentals, we're going to divide it into two parts. The first part will be a description by the panelists of the various functions of the WTO. So this is designed for those who may not be completely familiar with the WTO and its institutions and its goals and its member-driven nature. But at the same time, I would expect that everyone will learn a little bit of something, even regardless of how little or a lot they may know about the WTO. I know that I'm anticipating learning quite a bit from our panelists. The second half is aimed at discussing the successes, the challenges, the opportunities that are presented at the WTO. So getting a little bit more into the issues of our day that members are grappling with. So I hope that in the second half we're able to build on the foundation, and that this would be of appeal to our audience. So as Ken mentioned, the Secretariat colleagues are speaking not on behalf of members or the WTO. All right, well, let's go ahead and start with a discussion of the fundamentals. I will turn to Santiago, Ambassador Wills, former Colombian ambassador to the WTO and former chair of the successful fisheries negotiations that led to the fisheries subsidies agreement, which just entered into force in September. So very happy about that. Santiago, I hope that turn it over to you to discuss a little bit about how the WTO was established, its membership, the type of decision making, the consensus type decision making, and perhaps some of the key principles that members use, such as the concept of most favored nation. And then give us a little bit of information about the various agreements that are under the WTO rulebook and its organizational structure, and maybe throw in something on technical assistance and capacity building. So over to you, Santiago, for about 10 minutes. Thank you.
Great. Well, thank you so much, Angela. Thank you, Ken. Thank you to WITA, the WITA team, for inviting us today to participate in this seminar. I'm thrilled to be back in this forum and to share again some ideas on the fundamentals of the World Trade Organization and how the WTO was established. I've got to say, even though both Angela and Ken have mentioned this, but the views that both my colleagues in the Secretariat and myself will express today are our own and do not necessarily represent the views of WTO members. So, Angela, if you agree, I'll just start basically with a bit of the history of the WTO, how the organization was established, what was the origin of the organization, or at least the idea of the organization, and how that evolved. So I'm going to take you all back to 1947, right after World War II, when in Bretton Woods there was a few meetings, let's say, to create basically three organizations: what we now call the World Bank, what we now call the International Monetary Fund, and what we now call the WTO, but at that time would have been the International Trade Organization, that unfortunately, as an organization, was not established. But the substantive part of the organization, that was the actual provisions, the commitments undertaken on trade, came into force, and it started being applied. So that's the GATT, the General Agreement on Tariffs and Trade from 1947. So basically, through the GATT, the contracting parties at the time met and started negotiating the reduction of tariffs in their bilateral trade. That was followed by around 8 rounds of negotiations, including the Uruguay round that ultimately created the WTO. The first 5 negotiating rounds in between the GATT and the WTO were mostly dedicated to the reduction of tariffs. And we've got to say that it achieved an incredible reduction from an average on industrial goods from around 40% to about 4%. Then the following 2 rounds, we know them as the Kennedy round and the Tokyo round, they started dealing with other issues rather than tariffs that were mostly about non-tariff barriers, trade remedies, subsidies, and some other issues. In the Tokyo round, for instance, there were several plurilateral codes created, and this was a very important stepping stone in creating the WTO later in the Uruguay round. So what are these plurilateral codes? These were part of that group of countries that were negotiating their trade relations, let's say, through those rounds, decided to go a little bit beyond tariffs, and they created some codes that would be binding to those that agreed to be bound by those codes, mostly on subsidies and countervailing measures and on anti-dumping. There are a few others, but I would like to focus on those two. And I've got to say that since GATT 1947, that started with around 23 contracting parties, 23 countries basically at the time. By the Tokyo round, there were already around 102 countries negotiating. So you can see the big increase of the group of countries that were negotiating their trade relationships at that time. Then in 1986, this is where I'll focus a bit more because it was what created the WTO, the Uruguay round started. So the Uruguay round started not necessarily with a view of creating an international organization, but it was yet another round of negotiations on tariffs, going beyond tariffs or non-tariff measures, non-tariff barriers, trade remedies, services was ultimately included as well, the trade-related aspects of intellectual property rights, trying to improve a little bit the mechanism for the settlement of disputes that existed already in the General Agreement on Tariffs and Trade. And since 1986 to 1994, that round took place. But ultimately, the round created an international organization. And this is the World Trade Organization, the WTO. The WTO entered into force the 1st of January of 1995, meaning that it has now been alive for about 31 years. And now we're in a phase of trying to see how to improve the organization, how to adapt it, and how to reform. So very quickly, I'm just going to go through the functions of the WTO, what we do in the organization, what members do in the organization. I'm not going to go into the details because I know that both Roy and Eugenia will go into the details of some of those functions, the same as Padideh in the case of disputes. But I'll just list some of them. So one of our main functions is to administer the trade agreements. So those trade agreements that were negotiated and eventually agreed upon during the Uruguay round, one of the main functions that we have in the WTO is to administer those trade agreements, to follow up on the commitments. We are also a forum of trade negotiations. So the WTO is meant to provide that forum for all members to negotiate the trade agreements and multilateral trade agreements and plurilateral trade agreements. And I'll come back to this a bit later. Third, the settlement of trade disputes. I know Padideh will go a little bit deeper on this topic, so I won't stop myself here too much. But I must say that this has been a very important function for the WTO since I think up until around the end of last year, we had around 642 requests for consultations, meaning 642 disputes initiated. We would probably need to update this number to account for December and January this year, but that's quite a number for an international organization. We also have as a function the monitoring of trade policies, and I know that Eugenia will go into this a little bit later. And one other function that it's very important, especially for least developed country members and developing members, that is the technical assistance and capacity building. So let me go back very quickly to one of these functions, that is the forum of trade negotiations. The WTO was meant to provide the forum for members to negotiate the trade agreements within their multilateral framework, but also plurilaterally. And I am stopping here because you usually would hear that the WTO has only delivered 2 multilateral outcomes in its existence, in 31 years of existence. And that is true. I mean, we do have some amendments here and there to other agreements, but as complete, let's say, fully fledged WTO multilateral agreements, there's only 2. One, that is the Trade Facilitation Agreement, that I'm pretty sure that Roy will touch upon a little bit later, and the Fisheries Subsidies Agreement that was concluded in 2022, most recently in the 12th Ministerial Conference. If I'm able to share my view here, these are legally binding, legally enforceable agreements through dispute settlement with a possibility of some sort of economic consequences in case that there's no compliance. This is something that it's quite unique for international organization, for the WTO. And that is one of the reasons why it's difficult to negotiate fully fledged agreements in the organization, because it has consequences, because it is binding, because it is legally enforceable. So it's difficult actually to think about another international organization with a track record, even if 2 seems like a low number. a track record of negotiating multilateral agreements that are legally binding and legally enforceable is not an easy feat. The other function I would like to very briefly touch upon is technical assistance and capacity building. So this is one of the functions of the WTO in providing some assistance to developing members and least developed country members to implement the agreements, to implement their obligations, to allow them to think through new trade policies in a way that they're compliant with their commitments, but in a way in which they can fully integrate into the multilateral trading system, that they become part of the supply chains, they're part of the economic system. So in general, how do we carry out all these functions? So let me very quickly go through the legal and organizational structure of the organization. I'll start with the legal structure of the organization. So you've probably seen, you've read about the Marrakesh Agreement. You've read about Annex 1, Annex 1A, the GATT, SPS agreement, and that might create a bit of confusion. Where are all these agreements found? So just to give you a big framework of how things are established legally in the WTO. The Marrakesh Agreement establishes the WTO. And it's actually called that way. It's the Marrakesh Agreement establishing the World Trade Organization. This is where you will find the objectives, the principles, the functions of the WTO, the purpose of the organization. And annexed to the Marrakesh Agreement, you'll find the substantive disciplines and commitments that members undertook during the negotiations. So we'll find four main annexes. Annex 1 deals with basically the big substantive trade disciplines. Annex 1A deals with the trading goods. So this is where all the agreements related to trading goods are found, whether this is the GATT 1994, whether this is agreement on rules of origin, whether this is the agreement on sanitary and phytosanitary measures, technical barriers to trade, etc. This is also the annex where we can find the two multilateral agreements I was referring to, the Trade Facilitation Agreement and the Agreement on Fisheries Subsidies, basically because they relate to trading goods. Then we have Annex 1B that relates to trade in services. So this deals with international trading services in their different modes of supply. And then we have Annex 1C that deals with yet another big issue for the WTO, that is the trade-related aspects of intellectual property rights. So this is everything that comes from IP that is related to trade. We have then Annex 2 that I know Padideh will talk about a little bit later, that deals with dispute settlement. So Annex 2 establishes the dispute settlement understanding, or is the dispute settlement understanding that establishes the dispute settlement system, the mechanism. So here you will find the principles behind dispute settlement in the WTO, as well as the legal procedures for it. Then you'll find Annex 3, that I know Eugenia will very closely talk about this, that establishes the trade policy review mechanism. And finally, Annex 4, and this is something that I sense will be quite important in the near future for the organization. It's the annex that where the plurilateral agreements are included. So when I refer to plurilateral, it means that a subset of the entire membership is part of those agreements. So plurilateral versus multilateral means multilateral, all the members of the WTO are part of the agreement, but a plurilateral agreement means that a subset of the membership only is part of that agreement and legally bound by it. So those, currently we only have two agreements in force in Annex 4, but that's where you will find them. So, and now moving on to the organizational structure of the WTO, so that you can also have an idea of when we talk about a ministerial conference, general council, what we're referring to. So how are we organized? Basically, we have our supreme body, let's say our top decision-making body of the WTO is called the Ministerial Conference. This is the gathering or meeting of ministers, of all trade ministers of the members of the WTO. That usually happens once every 2 years. And partly, this is the reason why I think we're speaking today in this event. The next Ministerial Conference is meant to be held in Cameroon, in Yaoundé, at the end of March this year. So currently, as we speak, we're preparing very deeply that Ministerial Conference for ministers to be able to make certain decisions and show us the way forward, at least for the next 2 years until MC15. So Ministerial Conferences, our top decision-making body. So what happens while the ministers are not meeting? Who's taking those decisions? We have our top decision-making body in Geneva. in the WTO that meets around 5 to 6 times a year. It's called the General Council. And that's the meeting of all the top representatives of each member in the WTO, usually ambassadors. Again, they meet around 5 to 6 times a year, and they make the more day-to-day decisions on how to progress the multilateral agenda as instructed or as mandated by ministers. At that same level, the General Council sort of wears two different other hats. One is the hat that deals with disputes. So that's the meeting of the dispute settlement body. And then another hat that deals with the trade policy review mechanism. And that is the trade policy review body. So at that same level, the General Council acts as General Council, as DSB, and as TPRB, the Trade Policy Review Body. So then under the General Council, there's several committees, councils that they say progress as well the agenda, the technical work under the auspices or the guidance of the General Council. And these are 4 main councils. And I'm not going to go through all the specific committees because otherwise we would be here forever. But basically, the 4 main councils are the Council for Trading Goods, the Council for Trade-Related Aspects of Intellectual Property Rights. So as I mentioned in Annex 1C, this is the TRIPS agreement. And then the Council for Trade in Services, dealing with trade and services. The 4th council that I was mentioning is not really a council, it's a committee that was created later. So you won't find this in the Marrakesh Agreement as you might find the other ones. It was created in the Doha round in 2001 that is called the Trade Negotiations Committee. So in 2001, there was an attempt to launch yet another round of negotiations. And for that, certain committees were created for the purpose of negotiating. A framework committee that is called the Trade Negotiations Committee, and this is the only committee or council that is chaired by the Director General of the WTO. And that's been the case since 2001. And below the Trade Negotiations Committee, you will find other technical committees in a specific branch that are the special sessions dealing with negotiations. So there you might find, for instance, the Committee on Agriculture in special session to negotiate issues of agriculture. The Council for Trade and Services, SS, special session to negotiate aspects on trade and services. So this was something that was created later than the entry into force of the organization, as mentioned in 2001 in the Doha round. And since then, it has been a fundamental pillar, I would say, of the work that we do in the organization. That is, again, provide for the forum of negotiations for members. I wouldn't go into the details of other committees at this point. I know that Roy, for instance, will probably and will be in a better position to share some more information on that. But I want to go back to some of the topics that Angela was mentioning before yielding back the floor. And these are 2 things that I believe are very important. One is one of the main obligations, main commitments standing since 1947. That was actually one of the core principles of the organization, or at least that was the way it was conceived at the beginning. That is the most favored nation treatment. What does this entail? Most favored nation, MFN. You'll hear a lot about this these days. It talks about non-discrimination. So the principle behind it is to not discriminate between like products or like services, regardless of where they're coming from. So if I gave a special treatment to bicycles coming from X country, I should not discriminate bicycles coming from another country as long as they're like. So what's the principle behind it? Provide the same or like conditions of competition for like products or like services. That's one of the first commitments that members undertook, even since 1947 at the time of the GATT. One other thing I wouldn't want to miss saying is talking about decision-making. And this is yet another element of why it's so difficult sometimes to get multilateral agreements or any kind of agreement for that matter. And this is because according to the Marrakesh Agreement, the general rule for decision-making in the WTO is decision-making by consensus. So you might ask yourselves, what is consensus? What does that mean? So for us, and legally speaking, it means that nobody should formally object to a decision that has been put forward. What does that translate in reality and what has been the practice since the beginning? Since the beginning, it has really been a practice of sort of being responsible in how to interpret consensus, meaning that if I feel like I'm going to be harmed by that decision, I may be able to object. But if I don't, I let others move forward with whatever is happening. In reality, what that has become at this point is almost equated to unanimity. And this is something that it's not technically what it's supposed to be, but in practice, this is what's happening. So any member, if they formally object to a decision, the decision cannot be taken. In principle, not every decision in the WTO is meant to be taken by consensus, but that is certainly the general rule. And what has happened is that it is definitely the preferred practice by members. So to the beginning, that is the way that decisions have been taken. So imagine trying to negotiate and agree on a multilateral agreement on any topic that is legally binding, legally enforceable, with possible even economic consequences in case of non-compliance, and trying to get there with the agreement of 166 governments that are part of the WTO. It's not easy. So even for small decisions, garnering enough convergence to create the consensus needed to make decisions is not easy. So that's more or less where we are. I know that later, as part of the challenges, we're going to talk about a little bit about reform, even though you're going to have a specific session on it. So we can go a little bit deeper on it, more into the discussion. So for now, Angela, I think I'll leave it there. Thank you so much again.
Well, thank you very much, Santiago. You really laid it out very, very well in terms of the structure and some of the giving us a taste of some of the challenges to come. I'm glad you mentioned the Trade Facilitation Agreement and the Fisheries Subsidies Agreement. And those, of course, were reached by consensus among the members. So it can happen. It can happen. All right, Roy, we'll turn to you next. Because you have special expertise about how the WTO is administered, how the rules are administered through the regular bodies, because you serve as secretary to the Council on Trade in Goods, which is a huge responsibility, and you see a lot of the challenges. So perhaps you could talk about the committee structure, where a lot of the bread and butter work of the WTO is done, and mention as well the notifications, the transparency push that members are expected to comply with, how specific trade concerns are addressed, and perhaps something on the Trade Facilitation Agreement as well, since that's in your mandate. Thank you. Over to you.
Thank you very much, Angela. I know this is the third or fourth time we're mentioning the disclaimer, but I promised Victor that I was going to do it. So, Victor, if you're listening, this is my opinion, not the position of the members or the organization. In preparing for this session, it occurred to me, I remember there was a famous sketch by Monty Python, which is about what have Red Romans ever done for us. So we'll try to talk about what has the WTO ever done for us, to try to explain it in very simple terms. And then in doing this, I will not really refer too much to specific committees because I have very little time, but then I will try to explain more the general functions across all these different bodies that we have in the House, which is approximately 20 of these regular bodies. Santiago already mentioned the councils, but then we have many working groups, committees, all sorts of different considerations. The main function by far for these bodies is to administer the 60 or more agreements and decisions that we have. In fact, I actually brought with me a book in case you have not seen it. It's a book of around 600 pages where you have all these different agreements that have been negotiated through international cooperation. As Santiago explained, many of them more than 70 years, different iterations, revisions, different elements that we have taken into account to improve these agreements. The latest one being the one on fishery subsidies. All of these agreements share something in common, and is the fact that we are trying to provide transparency in terms of different types of policy measures and try to ensure that there is security, predictability in terms of the types of policy measures that can be implemented. And then, of course, the ultimate goal at the end of the day is to try to help the trade operators to know what the rules are so they can take their own decisions in terms of investment, whether they would like to take profit, have access into some of these markets, what are the limits in terms of the type of policy measures that can be implemented, etc. Right? So this is kind of like the general principle we have. And they establish the foundation on which international trade actually takes place. One part, which perhaps is not mentioned very frequently, is that because you have this foundation, it becomes relatively easy, or actually easier, to negotiate other forms of trade negotiations, trade deals, etc. If I can just give you a very quick example. If you agree that the duties that are going to be applied on certain products is 10%, 10% of what? So we have one agreement that actually deals with how you determine the customs valuation of the products, and perhaps it's taken for granted, but there are significant rules in these areas that have been developed over many years. So this allows members to really focus on other areas rather than having to reinvent the wheel over and over again in every single trade agreement that they have. To do this and implement the agreements, we basically have, three main functions. One of them is this transparency aspect, where the idea is that members are going to be providing official information to the WTO. And then the idea is that this information is going to allow us to monitor whether the members are actually implementing the agreement or not. And this is another aspect which I think is perhaps not so evident. One thing is to negotiate an agreement. A very different thing is to make sure that it's actually being complied with over the long term. All sorts of different issues are going to come, interpretation issues, new aspects that perhaps were not taken into account in the negotiations. How do we deal with this? How do we adapt, etc. And then through this information which is received, we actually try to make sure that the trade tensions that may exist amongst the members do not escalate. So there's a big dispute prevention type of function that is done by these different bodies. So it was already mentioned that we have had something like 600 and something disputes. We probably have had thousands and thousands of issues that did not become disputes precisely because we have this big machinery of issues that seek to prevent that the issues escalate to that aspect. Notifications on what? Well, we have something like, I think it's more than 200 notification requirements. The functions can change quite dramatically depending on the area. Let me tell you one where we have perhaps the biggest success, which is in the TBT area, technical barriers to trade. Here, the idea is that if a WTO member is going to establish a new technical regulation on things like, for example, what is the content of maximum residue levels of certain products, etc., then the idea is they have to submit some form of draft of that legislation, decree, or whatever the measure is going to be. So the other members actually have the opportunity to know that the measure is going to be implemented before it's actually done, and also to have the right to comment. The member receiving the comments is not obliged to do exactly what the others are telling them, but then, of course, they benefit in terms of trade governance for perhaps looking at issues that they have not really anticipated or that might be causing problems. I was checking one of our systems today. The latest one we have is traceability of new measure on traceability of food products in Vietnam. So, for example, if you are exporting food products to this country, then you learn that this is going to come. You can adapt even before the measure takes place. So you can prepare, you are not surprised. You don't lose money because you send a product that doesn't comply with the specific type of measures that are going to be implemented. There is a second function that has to do with, let's say, a peer review of this type of measures which are notified. It happens very frequently that members disagree as to whether they actually comply or not with the rules. So depending on the committee, depending on the body, they receive different names. Sometimes we call them trade concerns, sometimes specific trade concerns. In others, questions and answers. In others, we do not even have a name for them. It's part of the regular work that they do. They just do it. And then here the idea is that a member basically brings the issue to the committee and then complains that, in their view, perhaps that measure is not really fully compatible with the rules. This, of course, happens. Imagine coming back to my example of exporting food products to Vietnam. The exporter realizes that a new measure is going to come into place. They maybe think that this is not compatible. They contact their government, and their government actually bring the issue to the WTO, right? So there's one place where you can actually look at this very, very concrete type of issues. This is, of course, much faster and lighter than having a full-fledged dispute because the lawyers are not involved. It's really trade diplomats discussing the issues. We're going to discuss later that the success rate is relatively high, even if perhaps sometimes it's invisible. And then we keep the members accountable to complying with those rules that have been agreed. A final function has to do with, let's say, cooperation, incremental improvements, perhaps, to some of those rules. We have negotiations which are not necessarily about new agreements, but could be about small improvements on the implementation, on how to provide transparency as to how to deal with these different issues. Sometimes we also have experience sharing because perhaps there are new issues that are affecting the international community. And then the question is, what are the challenges? How have they been solved? So we can actually learn from each other on how to tackle some of these issues. So I know I'm very much aware of the time, so I'm going to stop here. Thank you, Angela.
Well, thank you very much, Roy. I appreciate that. It's very clear that so much important work is done by members that kind of flies under the radar. It's not the kind of thing that gets reported on every day, but the conference rooms are filled every day with members trying to resolve these issues, having this back and forth to prevent dispute settlement. To the extent possible, which is a segue into our professor's description now of the dispute settlement understanding and how members use that. Padideh, we're so delighted to have you here from the American University College of Law, and over to you now.
Thank you so much, Angela, and thank you, Ken. Thank you, WITA. It's an honor and privilege to be part of this this panel. I'm going to share a quick PowerPoint if I can locate it, if I can do it myself. I'm going to Zoom. I always have problems finding being able to share. There it is. I think I'm going to do it in okay, so folks can see this. I think it's important to remember, and I think it was mentioned right now, with regards to going through dispute settlement is not the only way to resolve conflicts. And I think what was mentioned about specific trade concerns and other areas where members can discuss potential disagreements happens before you come to dispute settlement. Maybe unlike things flying under the radar that you just mentioned, dispute settlement has not flown under the radar, has been more in the news than maybe other parts, other issues relating to the WTO in particular, other than probably negotiations. So it's important when I teach to talk that the dispute settlement system under the WTO conceptually is a bit different than one would to think about litigation. It's really about nullification and impairment of benefits. Basically, if you believe that everything is reciprocity, members have negotiated, they have come in, they have given up something to get something in return. And when the feeling is that the bargain hasn't been met, that they opened up their markets, but in return, other members did not reciprocate, or they lowered their tariffs, but they put something else, some other non-tariff barrier up, or put additional fees, then that's how dispute works out. So there's been nullification and impairment of benefits. So conceptually, one has to think of it as a bit different. It's not about getting damages from the other side, or to sort of, I think the push has, the concept behind it has to be more about we have this reciprocity, we have this negotiation, we had certain expectations, and now they have been nullified and impaired. This started off, as was mentioned by Santiago, the idea of nullification and impairment existed in the GATT, Article 22, Article 23 in particular, but under the GATT system, it was based on a consensus system in the sense that only if then the contracting party, now the members, felt that their benefits have been nullified and impaired due to a violation, they could then ask the other party, and the other country had to agree. The other member had to agree, so there had to be consensus to go in front of the panel, and after that, there need to be a consensus also among the parties that this was a joint. Whatever the report was, that they agreed to its adoption. So basically, it became a forum for parties who agreed to be in front of three panelists, and it was very difficult to get consensus to either form a panel or to actually adopt a panel decision. One of the big, successes, one would say, or one of the achievements of the Uruguay round that created the WTO was to change that system into a reverse consensus, where basically panels are formed now automatically, although still with the dispute settlement body, as Santiago mentioned, one of the faces of the General Council where the members exist, but they really don't say you can't form a panel. Panels are formed if they get to that stage, and decisions, or I should say reports, are adopted if they get to that point. Now, I would tell now, because of the lack of an appellate body, it's possible to not get those decisions adopted. It also, the Uruguay round and the Marrakesh Agreement created a standing appellate body with 7 members that is standing in the sense that they have terms and they're not supposed to go away once the panel itself dissolves. Panels really are more like arbitration. They're there, they go through the dispute, and then the panelists sort of disband. The appellate body, that is not the vision for it, is that they stay, they do listen to, they have hearings at three-person bodies, but it's really, they're supposed to work together, and they have terms of years. The understanding, as Santiago mentioned, on rules and procedures governing the settlement of disputes, called the DSU, is Annex 2 of the Marrakesh Agreement, that basically further elaborates this concept of nullification and impairment of benefits that existed under Article 23 of GATT 1947. So it says this is a further sort of expansion of this rule-based system run now. And the DSU basically delegates authority to the dispute settlement panel body to establish panels, adopt panel reports and appellate body reports, and then subsequently maintain surveillance for implementation of rulings and recommendations, and if necessary, authorize suspension of concessions. And it is comprised of representatives from all WTO members. Now, according to the WTO website, I was actually surprised, between January 1st, 1995, and it went till December 31st, 2024, the DSB met 490 times. That seems quite a lot of times to meet, but that tells you how active the dispute settlement process has been. So very quickly going through the process of dispute settlement, it starts initially with a request for consultation. And I would say one has to think about this as when a member makes a request for consultation against another, it's like this does not happen overnight. There probably were specific trade concerns. There were probably certain things that were talked about before. At this point, it becomes, well, I want the whole world to know I have a problem with this measure of yours, this governmental measures. Obviously, it has to be a governmental measure to be part of the dispute settlement system. Then, if they choose to proceed, and not all consultations end up with panel formations, some do. If things are not resolved, they move to panel formation. after a certain period of time. And that's where the terms of reference come in, where you sort of explain what measures you have problems with and what the basis is that the violations you think have taken place. It's very important in this case to make sure that you identify the measures that you're thinking at issue, that another member's measure that you have a particular problem with, whether it's your tariff or whether it's some regulations, some technical regulations, a subsidy scheme, whatever it may be. Because if you don't raise it at that point in time, it's not possible to then raise it later on. That sort of frames the dispute. The composition of the panel is then made, and I'm not going to go into the details on that. The Secretariat works the composed panel members, and then there is an interim review where parties do get to see what the decision is likely going to be. But there, it's particularly important to review the descriptive part of the report for the parties, because technically WTO proceedings are confidential, and things, and especially unless a governance member choose to do so, are not, the WTO does not make them available, the filings of the parties. Then the panel reports go to the parties, then they're adopted by the DSP or appealed. So under the DSU, there is a right to appeal. Since December 2019, when the last WTO members sort of term expired, there has been no appellate body because there has not been agreement, or there has been objections to appointing them. So it's a not functioning appellate body since then. Subsequently, whether it's adopted or appealed, one has to look at the implementation of the dispute. Members are given whoever loses, basically the respondent, if the measure at issue has to be changed, there's some implementation time, is a reasonable period of time given to implement. And if it is not implemented, then it can move to either compensation, which is completely voluntary, or suspension of concessions, or some people call it retaliation. And there is, when it comes to retaliation, the question is, or suspension of concessions, are they commensurate to the amount of nullification impairment? And there we can end up with some sort of an arbitration to determine the level of suspension of concessions. These are numbers. Just want to say in terms of how much the dispute settlement system has been used. And just a comparison, International Court of Justice cases since its inception, 1947, has been 201 cases and delivered 129 judgments. The dispute settlement system, I only had this data till December of 2024. And I think Santiago has a higher number, 631 requests for consultation. Of course, they don't all become panels. Then 376 panels established, 297 panel reports issued. That's only till the end of 2024. And then about 197 panel reports. I think that I have to say that it was, I said that the appeal rate when the appellate body existed was higher than what is imagined when the DSU was negotiated. So that is about 66%. But since the demise of the WTO, disputes have not stopped, and we have had still cases brought. I had people look up all the cases. These were all the cases since 2020 that have asked for requests for consultation, and some have been appealed into the void because there is the right to appeal, and that now doesn't exist. But some have also agreed on procedures under Article 25, which is an arbitration, provision. And then there has also been created in 2020 a multi-party interim appeal arbitration agreement, or MPIA as we call it, which is a political agreement where signatories states may pursue arbitration under procedures that are outlined under MPIA and in accordance with Article 25 of the DSU. Just an example that even in 2025 alone, they had at least 12 consultations, 6 against the United States, 2 against India, 2 against Canada, 1 against China, and 1 against the EU. I'm going to stop sharing there. I know that we're short of time, but maybe in the next part, we can talk more about how things are evolving. Thank you.
Yes, thank you very much. That's a really good foundation, I think, and then we can get into some of the challenges. Eugenia, I would turn it over to you now to talk about how the monitoring function at the WTO works in terms of the trade policy reviews, the formal reviews that are conducted periodically on each member, as well as the monitoring overall that so many members rely on. So over to you, Eugenia.
Thank you, Angela, and good morning or good afternoon to everyone. I'm going to try to be short, and if I go over, please, you can let me know. Well, as Santiago said, the trade policy review mechanism was established. It started during the GATT, but it was established under the WTO agreements in Annex 3. And it means that it's part of the agreements, and this is a compulsory. All members have to go through a review. It's not a choice, and this is important to let members know, because sometimes they ask us why we have to do this. It's part of the agreements of the WTO. Another important thing to say is that this is not a legalistic exercise. The trade policy review mechanism is an economic analysis, is an economic evaluation, and therefore is not intended at all to serve at the basis for enforcement of obligations. Nothing that we write in a TPR review can be used in dispute settlement, which is also very important when we want to obtain information, and is not intended to impose new rules or commitments on members. This is a transparency exercise, and what we do is explain the policies that members are taking throughout the economy, because we actually go beyond the agreements of the WTO in the sense that we're covering competition policy and investment, which we don't have agreements in the WTO yet. So we do an evaluation of the members' trade policies and practices and their impact on the functioning of the multilateral trade system. And we say we do it, okay, it's not the Secretariat that is undertaking the review. The review is undertaken by the members under the trade policy review body, as Santiago already explained. And the review is based on two reports, a report written by the Secretariat, and I can explain a little bit how it's done, and a review a report by the government. So the trade policy review body will take those two reports, and members based on those reports will ask questions to the member under review. And as you know, as Roy said, in the trade policy review, they're called questions, in others, concerns. But what the members would want is more clarification on both reports. And in the case of the Secretariat report is written basically under our responsibility, and it focuses on all the members' trade policies and practice, and they are examined in the context of the members' broader economic situation. And what we mean with this is that we look at both social, the difference between developing and developed country, etc. And the Secretariat reports are basically drafted, based on already available information in the organization, and that means all the notifications that Roy was mentioning. Also, we send questionnaires to the members, and we obtain information directly from them. We get information from other organizations, and we do our own research with academia, etc. Also, something that is very important is that what is seen of the trade policy reviews is just a report. But to produce that report, there is a huge background of information and knowledge that we have. We have to engage with the member, and this is a procedure that will take maybe 9 months. we usually visit the members on the review. And I say usually because sometimes because of budget constraints, we cannot do it. However, we gain a lot of information through the visits to the report, through the members, because we're not just talking to the government, but often we talked always also to NGOs and to the private sector, where we gain a lot of information to write the reports and to give really the flavor to the report, to understand how policies are implemented and the impact of those policies in the country. Now, I'm moving to the monitoring, and I want to say, for instance, that the monitoring part, that is the difference between the trade policy review mechanism and the monitoring, is that the monitoring is an ongoing process. This is in the Annex 3 says that when members take a policy, a change of policies, it should be notified. However, this has never been done. It's actually, there has been only one notification in the history. Okay, but then the monitoring, what the monitoring does is that they have a process, I'm moving, in which they ask, I'm over time, but I will try to finish very quickly. What they do is that ask members for twice a year for the measures that they're obtaining. The secretary does their own research, and they put out a review at the end, an overview of what has happened during that year in the trends of the measures that the members have taken. Thank you.
Well, thank you, Eugenia. That was, I think, really useful in showing how much members rely on this type of work and use the opportunity to periodically evaluate each other, as well as to do the ongoing work of monitoring. So we have about 15 minutes left. And I think what I'd like to do now is to kind of move into the section relating to the successes, opportunities, the challenges that the organization is facing in each of the areas that you talked about. So Santiago, let's start with you. You've been facilitating the chair of the General Council, of course, the Director General, as well as the facilitator for reform. Perhaps you could give our audience a sense of what some of the crucial issues are relating to reform that members will be dealing with in the lead up to MC14 at the end of March, and of course beyond. And I would note here that we will be hearing from ambassadors directly over the next couple of sessions on their views about reform. So over to you, Santiago.
Excellent. Well, thanks again, Angela. I'll try to keep it short. And we'll try to focus as well on what is intended to happen in MC14 on reform. I think on the other sessions, you might go deeper on what's being discussed in each of these topics, so I won't go into that detail. So since the start of the process, I think reform, the WTO reform process through the facilitated Geneva process, as you mentioned, through the facilitator, that's the ambassador of Norway, Peter Olberg, the discussions have mostly have related mostly to three big categories: reform on governance, reform on what we call fairness, and what we also call issues of our time. So what does this entail? It's basically on governance. You might find topics, it's more the institutional reforms. You might find topics like decision-making, for instance. On the broader category of issues of fairness, you might find matters like development and special differential treatment. You might find issues that we also call here level playing field issues. So a matter of whether the provisions are fair. Is there anyone or members just taking advantage of some of the provisions? Are they being effective or not? What needs to be created? Is there enough policy space for developing members to industrialize? So all of this would sort of fall into that bigger category of fairness. And then the other third category, a big category, is issues of our time. So what are the topics that we need to address for the future, whether this is AI, digital trade, climate change, etc., etc. So what's intended for the Ministerial Conference? Of course, during the discussions, this has been distilled further. And for now, we have, and again, my disclaimer at this point is mostly on substance. This can change because we're in the middle of the process. We still have the whole of February in front of us, where we'll have some meetings on reform. So this can change a little bit on how things will actually happen at the end of March. But for now, what is intended is that ministers at their level, very high level, political level, should have a discussion on the foundational issues of the WTO and its principles. So basically, for them to address what kind of WTO they would like in the future, what kind of values do they share, do ministers share, and how they want to see these values reflected in the WTO. So again, a very high-level political discussion on the foundational issues of the WTO. Then we would love for ministers to give us some indications, some guidelines of how would they want us to proceed on the reforms that need to happen. So reforms on decision-making, how do we make this better, or a results-oriented decision-making process, for instance, how we can deviate a bit from our practice or not, or maintain the practice, depending on what ministers would like. Some guidelines as well on how to make reforms on development and special differential treatment, and also on the other topic I mentioned, on level playing field. So what we would like for them is to have very good political high-level discussions on these matters, but also to give us some sort of green light on a work plan on what we need to do after MC14. So how should we structure the work? What kind of reforms do we want? And how do we actually carry out that work? So in terms of the reform, that's mostly what we're aiming at for MC14. And we're hoping to get those results from ministers, those indications from ministers. Obviously, reform is a core part of, or will be a core part of the Ministerial Conference. It's not the only part, but I think we don't have enough time to go into the detail of other topics that might follow in MC14. So I'll just leave it there in reform for now.
Great. Well, thank you. And it's definitely a project that will take some time. It's not something that can be done overnight because reform means change, as we know. Okay, so at this point, let me turn to you again, Padideh, to talk about dispute settlement and what some of the things are that the WTO members are talking about in terms of reform of dispute settlement, which is a bit of on a different path from the reform that Santiago is describing, but is nevertheless incredibly important to so many members.
I just want to start off. Thank you, Angela. I'm mentioning we looked at the success of the dispute settlement system. I mean, it has been utilized because it has been needed, but almost maybe the success was going at a different pace. When negotiations don't happen, people go into dispute settlement. So it dealt with a lot of issues that maybe it should have been moving forward here on the negotiations part. And I would say that, so you have in the Marrakesh Agreement, exclusive authority to adopt interpretation is given to the Ministerial Council and to the members. There's also this language in the DSU that the DSB cannot add or diminish the rights of the members. At the same time, it also says that it's the appellate body and the panels, the system, that has to clarify the provisions in light of public international law. So there's a tension between clarification, in my mind, and what you're talking about, adopting interpretation. So the issue has been, that's spearheaded in somewhere by the United States, and it starts a long time ago, multiple administrations, both Republican and Democratic, that the appellate body in particular has added to the US obligations or diminished rights by failing to comply with WTO rules, that it has addressed issues, that it had gone beyond its mandate. And for that reason, there's this persistent overreaching from the US's perspective that relate to the US sort of stopping or not agreeing, objecting to reappointments of appellate members. That's why I think the main one of the main topics is now, what are we going to do with the appellate body, given the fact that there is the right to appeal into this body? So there are issues that I think of concern of members in terms of, and some of these concerns I think have been shared broader than the US, with regards to deadlines or sort of deciding, how it's supposed to be done. For example, appeals within 90 days, there are certain term limits, but things were taking much longer than they were supposed to. And appellate body members were continuing to serve after their expiration dates because the cases continued to be much longer. The idea of issuing versus fact versus law. I mean, that's one thing that we as lawyers always know. The appellate body is supposed to limit its scope to only facts. Most of the issues that have been been raised have to do with trade remedies. So there's a particular sort of sensitivity as it comes, as I would say, to the issues regarding in the trade remedy space, in the anti-dumping and countervailing, especially from the United States perspective. How much can it intrude into what they consider the legitimate government policy space? There is a talk about there has been no right to remand, which has been another issue for the appellate body because it felt that it needed to resolve issues at the appellate body stage without being able to take it back to the original membership. The strictly confidential nature of it has always been also another topic that has always come in. Should there be now they are allowing, if parties agree, for some of these to be public in the sense that they can watch the proceedings, the transparency, sort of increasing the transparency of the procedure. So I think there's a lot of conversations about how to make it function in a way that would maybe address some of the concerns, specifically that the United States and other countries have had. I always think about Bob Hudak, who passed away long time ago now. But one of the last conversations I had with him is that he actually foresee that there was going to be some kind of a reaction against the dispute settlement mechanism if it became automatic. So in a sense that there may be some decisions that members will lose, some decisions that they won't like. But one thing that I really want to underline, there was no other forum. There is no other forum where smaller countries or even middle-sized countries can bring a case against a big market. It doesn't level the playing field, but the dispute settlement system made that possible for smaller countries, and a rule-based system. And most importantly, the multilateral system said, please address disputes through this system, as opposed to taking unilateral action. And I think that is sort of the linchpin, right? And creating security and predictability through a rule-based system without the dispute settlement, a functioning dispute settlement system, we cannot have that. We have gone back to the consensus system in a way, because now if a party doesn't like the decision, it can just appeal into a void, and it doesn't become it's not adopted. So I know that their workings are on mutually agreed solutions, on third-party rights. There are issues on strictly confidential information. There's the conversations on remand. So there's a lot of attempts being done to sort of address those complaints with regards to time mandatory deadlines, etc. But from an outsider's perspective, the issue is the world ready for a system, for a rule-based system where there is no other international mechanism, there is no other place where these issues can be addressed? And I think what made this system particularly effective and problematic maybe was the fact that there was a potential. There is no ICJ can't of enforcement through suspension of concessions. That made this system particularly vulnerable if we are not ready yet for for a dispute settlement mechanism that has that weight. So it's always been sort of negotiations, understanding as public international lawyers that we are limited by the reality of the politics in which we live in. I'm going to shut up now and let you go.
No, thank you. Thank you very much. These are such important issues and many controversy, much controversy surrounding them. So thanks for laying them out. I think it's really important to note that still, even these days, half of all the cases that are brought are resolved, settled, or the members decide to adopt the panel report. So the dispute settlement function is alive and well, even though it is hampered and there is no finality in the system if someone appeals. So we have just a couple minutes left. Roy, I want to turn to you. If you could describe perhaps some of the challenges that you see in your world, notifications, for example, but also how the members have been able to come together in reform by doing. Just 2 minutes, please. Thank you.
Thank you, Angela. I'll be as quick as possible. There was a joke in the 1970s, which was that the meaning of GATT was the gentleman's agreement to talk and talk. So the perception was that nothing was happening. Some people think the same of the WTO, but then what do the numbers say? Is this really the case? When it comes to notifications, I mentioned that there are about more or less 200 notification requirements. You will probably be surprised to know that only last year we had more than 9,000 notifications. So that's an incredibly high number of communications which are submitted in compliance with those requirements. We do not really have a mechanism to tell you overall if members are submitting what they need to submit. We did an exercise last year with respect to the trade in goods area. And I was personally shocked, and I was shocked because I did the calculation, and it was like 77% of the notifications that have to be submitted had been submitted, which I think the number was much higher than I or than many other people anticipated. Of course, the fact that you submit a piece of paper doesn't mean you are complying with the requirement, because you would also need to look at timeliness, completeness, is it accurate, etc. But we do not really have mechanisms to provide you with that other kind of like bigger kind of picture. What are the main challenges when it comes to notifications? Well, the obvious one is to ensure that members submit what they have to submit when they have to submit it. But then there's a growing sense that perhaps we need to have new notification requirements because the old ones do not necessarily capture some of the new areas. And for example, here in subsidies, state support is the one that is frequently mentioned by people. We have capacity gaps. For some members, it's incredibly difficult to comply with all these requirements. In some governments, you have armies of people preparing and reviewing the notifications by the others. Some of them are very complex. You need interpretation, not so clear what needs to happen, etc. There is an information overload aspect as well, because you receive so much information. How do you actually review it? And then one last aspect has to do with the political tensions we have now, because if you have political tensions, then that is not necessarily conducive for members wanting to provide some of this information, because then they start becoming more strategic as to whether they want to show that information or not. When it comes to the trade concerns, I think here, and it is very regrettable, I think we have been quite successful, but this success is invisible because we do not have a record of what is resolved. In the SPS committee, they do, and they have been having this for many years. So of 620 trade concerns, it turns out around 56% of them have been actually notified as resolved or partially resolved. In the Council for Trading Goods, we tried to do a similar exercise last year. It's still ongoing, and even with the partial information we have, and again, I was shocked because I didn't think it was going to be that high, but between 40 and 50% of the trade concerns that have been raised were actually reported as resolved or partially resolved. And then one challenge when it comes to the trade concerns is that precisely because you have that problem with the dispute settlement understanding, many of the discussions stay forever in these committees or the council. So you have some issues that have been discussed there for 8 or more years. I'm going to stop here. So perhaps just one last point I wanted to make is that the story here is not really about making work something that doesn't work, is how to improve something that is already working. Thank you.
Thank you. I think those statistics are really compelling to show the workaday types of things that members deal with. Eugenia, just a couple of sentences, please, for the very last part here. Yes.
Okay. I think I think that the trade policy review mechanism has really, the engagement of the members has really increased, which is it's very welcome, not only for big members, but for small members. There is a lot of interest, a lot of participation in the meeting, a lot of questions and answers. And you know, for all members, the big ones, obviously there is an explosion, but even for very small members. And I think that they really appreciate this, the interest that they have in their trade policies. And I think that what this has brought is that we can identify technical cooperation needs, and there is more policy cohesiveness in those small member countries, because they're talking, they're sitting down and they talk. The other thing is that I think that we have promoted notifications, because they start notifying as soon as we start doing the reviews. Biggest challenges that we have challenges in terms of capacity for many members, in terms of lack of data, because some members don't even have trade data, and it's very difficult to do a trade policy review without data. And the other issue is human resources in the human and resources in the Secretariat, because we've had a lot of people that have left, and that's so we're doing the same work with, I think, maybe 1/3 less of the people that we used to have, and that is compelling. But I think that all in all, and in terms of the monitoring, members are really, really appreciating the monitoring function, especially when in this geopolitical situation, because it benefits everyone in a sense.
Well, thank you very much. Thank you. And I think it shows that, you know, you see a swan serenely on Lake Geneva, but underneath there's a lot of peddling going on, and that is definitely what happens at the WTO in terms of all of these institutions facing tremendous challenges. But I like to think that members see tremendous value out of what goes on at the WTO. So I hope this session was able to inform our global audience about the fundamentals of the WTO and a basic introduction into some of the challenges that our members face. More to come in our future sessions. And I turn it back over to Ken. Thank you.
Thank you, Angela, Roy, Eugenia, Padideh, Santiago. This was a terrific session. Great introduction for so many people who maybe are familiar or are not familiar with the WTO system. There is so much peddling beneath the surface, dynamism that is going on there, and I don't think it's well discussed around the world, and that's what we're trying to help convey. Did have a note, just we don't usually get these during our sessions, but former trade negotiator, senior trade negotiator wrote us and said that they already learned a huge amount. And thanks for such excellent presentations. I want to repeat that back to you because I agree completely. I know our audience does as well. And we look forward to hosting our friends again for our future sessions that we'll be having. Angela, thank you for working with us on that. February 4th and February 13th, we'll be discussing MC14 and reform proposals. Thank you very much for joining us, everybody. Have a great day. And if you are in DC or elsewhere where it's extremely cold, please stay warm and stay safe. Thanks, everybody.
Thank you. Thank you. Thank you so much.